Hello and welcome to Learn and Score. To the listeners, there is a request. We do not authenticate any information, whatever we are sharing with you. So, our trial is only to read out from the materials and the books which are available with us. And you are recommended to cross check with the information whichever is available with you. If you like the effort, please share and subscribe and encourage us. Thank you. And in this video, we are going to cover two questions or the concepts which can be used to answer two questions. One is droit administratif or the administrative law in France. Conseil d'État. By a wild guess, we may say that this may come for 6 marks or 10 marks. And the other question we are going to cover is the administrative law in India, which we can guess like for 15 marks or 20 marks. Let's start with the first one, that is the droit administratif. Right. The meaning is, in France, the distinction between the public law and private law has been observed not only theoretically in signs of jurisprudence, but also in practice. A separate system of tribunals for the administration of public law has been established there. Droit administratif is that part of public law which deals with the rights and liabilities of the individuals in relation to the administration. This law is administered by the special tribunals of the administrative courts. Conseil d'État is the highest administrative tribunal in France. History. Droit administratif is a specialized law born in France. It is very old. It was given honor and put in regular practice by Napoleon in the 18th century. Object. It gives cheap, immediate, and efficient remedy to the aggrieved person. Characteristic features of the French administrative law. There are some important characteristic features of French administrative law. They are: number one, body of special rules. The relation of the government and its officials towards private citizens have been regulated by a body of special rules. They are quite different with the rules which govern from one citizen to another citizen. Second one, different courts. There are two different types of courts. One is ordinary law court, the other one is the administrative court. The ordinary law courts administer the ordinary civil law between private citizens. It administers purely private law. The administrative courts administer the law between private citizens and the government, including its officials. The third characteristic, tribunal des conflicts. Tribunal des conflicts means court of conflicts. If a conflict of jurisdiction arises between the two systems of courts. It is settled by a special tribunal called as Tribunal des Conflicts. This tribunal solves such problems and conflicts between these two sets of courts, that is, the ordinary law courts and the administrative courts. The fourth characteristic, protection to government servants. Droit administratif has a tendency to protect the government servants from the control of the ordinary civil law courts, who performed his duty with good faith even though such act of the servant consisted guilty or illegal. The fifth characteristic, Council d'État. It is the highest administrative tribunal in France. It is staffed by the judges of great professional expertise and by a network of local tribunals of first instance. Wade praises this tribunal. He says, courts of this kind, whose work is confined to administrative law, may have a clearer view of the developments needed to keep pace with the powers of the state than have courts which are maids of all work. Certainly, the Council d'État has shown itself more aware of the demands of justice in respect of financial compensation. This is the end of first question. And now let us proceed to the second one, that is the administrative law in India. As we guessed, may come as 15-mark question or 20-mark question in third semester from the administrative law paper, unit 1. Okay, so let's see about administrative law in India. Right. So we can divide this into different side headings as before the independence, after independence or constitution, disadvantages, and then next we can conclude finally. Now starting with before the independence. The administrative law was in existence in India since before Christ. Kautilya at Chanakya wrote a book explaining about the administration and the administrative law. During the Muslims' rule, the Hindu administrative setup disappeared. Since 1600, gradually our country went under the rule of British. In fact, the East India Company, the first English ruler, was nothing but an administrative branch of the British king and got only subordinate legislative powers of charters 1600, 1609, etc. The real rulers of our country were British Parliament and Crown. The real legislative power was vested in them. The Governor Generals and the governors were real administrators and executives only. The British Parliament enacted several acts, rules, regulations, charters, etc. for the administration of India. On behalf of the British Parliament, the governors and the Governor Generals implemented such laws in our country. The British Parliament delegated certain legislative powers also to them. Yet that time, the purpose of administrative law were police state and law and order only. The primary purpose of the British rule was to exploit the wealth of our country. Dadabhai Naoroji, the founder of freedom fighting movement, estimated that the Britishers exploited India around 30 million to 40 million pounds per year. Even under such circumstances, also, the British Parliament made certain acts relating to public safety, health, morality, transport, labor problems, and relations, etc. The first public corporation was established under the Bombay Port Trust Act 1879. Several acts were enacted empowering the executives to issue permissions, suspension, and revocation. But there were no controlling measures over the administrative authorities, being all of them were Britishers. The next side heading, after independence or constitution. We got independence with effect from 15th August 1947. The Constitution of India came into force with effect from 26th January 1950. After these two important events, the administrative law has played a vital role in the prosperity of the nation. The Nehru government adopted 5-year plans for the speedy development of the nation. Social security measures have been speeded up. Our constitution provided the fundamental rights from Articles 12 to 35, Part 3 to every citizen. The directive principles of state policy are enumerated in Articles 36 to 51, Part 4. The provisions of Part 3 and Part 4 impose great liability and responsibility over the administrators. Since then, the administrative law has been given importance in India. The basic constitutional principles, the doctrine of rule of law, and the doctrine of separation of powers have been recognized in India and adopted with slight variations suitable to the Indian administrative atmosphere. Unlike Britain, India adopted the doctrine of pleasure in a new way, adopting the principles of natural justice from Articles 309 to 311. The appointment and services of the executive have been regularized from Articles 308 to 323 under the heads Services under the Union and the States. Part 14, Chapter 1, Services, and Chapter 1, Public Service Commissions and Tribunals. Part 14a, Articles 323a and 323b. Welfare of the people is the philosophy of our Constitution, besides law and order. Taking this inspiration, the Parliament has enacted several acts, viz. the BD Workers Welfare Fund Act 1976, the Companies Act 1947, the Maternity Benefit Act 1961, the Payment of Bonus Act 1965, the Equal Remuneration Act 1976, the Industrial Employment Standing Orders Act 1946, etc. Therefore, the administrative law is an instrument to serve the poor, the middle class Indians. Now coming to disadvantages. The administrative law has been characterized as the most outstanding legal development of the 20th century. It has given a great help to the Indian people for uplifting their lives. There is no doubt that administrative law is an important branch of the government. All the welfare programs and schemes announced by the Parliament and the state legislatures could only be implemented by executive. Every rose has thorns. Similarly, our administrators and administrative law are not exception. Lord Action says, every power tends to corrupt, and absolute power tends to corrupt absolutely. It is proved absolutely correct in the case of our government employees. Some Indian jurisprudence criticize our executive as rigid bureaucracy and white elephants. They also opine that our government departments, public corporations, and governmental departmental undertakings are filled with excess staff, with less work and less output. In spite of the speedy work, our executives are famous for snail running. When compared with executives of other countries, added to this, our political policies adopted since the independence have proved in vain. Due to the mutual cooperation between the political leaders and the bureaucrats, corruption has been increasing year by year. Particularly after 1991, in which year the policies of globalization, privatization, disinvestment, etc., have been introduced in India, the corruption has been increased many folds. Now, India stands at 70th position in corruption in world ranking. Several varieties of scams involving public money, lakhs of crores of rupees, have been publishing day by day. From an attender level to the Prime Minister level, several executives are involved in such scams. Wealth is being concentrated in a very few persons, and several lakhs of crores of rupees have been diverted and deposited in the foreign banks. At the same time, crores of people have been suffering with unemployment, shortage food, residence, etc. This is the result of inefficient and corrupted executives. Due to the age-old policies, rigid and corrupted bureaucracy, and politicians, we could not compete in the world market economically. We could not compete in Olympics, whereas small countries are getting gold medals. Our public corporations and governmental institutions are nicknamed as white elephants and blind horses. Some of the jurisprudents are of opinion that there is a lack of efficient control over the administrators. See the difference between the programs of Doordarshan and programs with those of private channels. Compare the function and efficiency of telecommunication department and other cell phone companies. You find a clear difference. Due to excess delegation of legislative powers and excess executive powers led to corruption, political influence, illiteracy, etc. Wade says, party system give the government of the day such powerful hold over parliament that parliament's traditional control over the executive has been progressively weakened. So now let's conclude. There may be some genuine comments over the function of the Indian administrators, but all criticisms are not true. After independence, India developed to a great extent. Of course, this development may be lesser than China, Japan, America, Taiwan, Israel, etc. But we cannot blame entire mud on the administrators. The main reasons depend upon the policy making powers. For the faults of the political decisions, the administrators could not be blamed. There are Articles 226 and 32 through which the aggrieved person can approach the High Court and the Supreme Court and can seek redressal for the injuries caused by the administrators. In fact, the administrative law is an effective instrument of middle class and poor Indians to combat governmental powers through the courts. A democratic government must be equipped with the powers adequate enough to discharge its enormous functions competently. But such a government has to be accountable ultimately to the people who have elected it. So, this is the end of the administrative law in India. That is the second question of today. And I would like to share the source. Here is the book written by Gade Veera Reddy, that is Sujata Law Books Private Limited. This is the source from where I have read the content. And if you like this attempt, please share and subscribe for the next videos to be notified to you. Thank you for listening.